The bailiff called the case number, and I shuffled into room 4C of the Grand Traverse County Courthouse wearing a canvas barn coat that still smelled like diesel and cold storage. My son didn't look up from his legal pad. My daughter-in-law looked up plenty. She gave me the same expression you'd give a stray dog that had wandered into a wedding reception. Then the judge glanced at the deed exhibit in front of him, glanced at me, and stopped moving entirely. "Mr. Kessler," he said, and his voice had gone quiet in a way that made the court reporter's fingers freeze over her keys. "Before we go any further, I need you to explain something to me personally. Why does your son's name appear as sole owner on the deed to the house you have lived in for 40 years? The room went still. My son's attorney, a sharp young associate named Palmer Voss, who had not stopped writing since 9 o'clock that morning, actually set his pen down on the table. Just set it down, like he already knew whatever came out of my mouth next was going to matter more than anything he could write. I looked at my son. Bradley wouldn't meet my eyes. My daughter-in-law, Vanessa, had her hand resting on his forearm, the kind of touch that looks supportive to a jury and feels like a leash to the person underneath it. Nobody in that room, including my own son, had any idea who I actually was, or what I had spent the last 4 months building underneath the floorboards of my own quiet decline. Thank you for sitting with me today. Before we start, I'd love to know, have you ever had someone you trusted try to convince you that you were the one losing your grip on reality? Leave it in the comments. Your answer matters more than you think. And a quick note before we begin, some names and details in this story have been changed for privacy, but the heart of what happened is true. My name is Warren Kessler. I'm 68 years old. I spent 26 years as a colonel in the United States Marine Corps, and the last 14 running 81 acres of cherry orchard on the Leelanau Peninsula in Michigan, the same land my late wife Colleen and I bought the year I retired, back when the trees were saplings barely taller than our daughter-in-law's designer heels. Colleen died 2 years ago. Pancreatic cancer, 11 months from diagnosis to the last breath. I buried her under the northernmost row of Montmorency cherries, the ones she used to say tasted like something worth waking up early for. I still walk that row every morning before the sun clears the bluff, because it's the only conversation I have left with her, and because old habits, once you've kept them for 4 decades, don't know how to die just because the person you kept them for did. My son Bradley is 41. He's a managing director at a boutique investment firm in Chicago, the kind of title that sounds impressive on a business card and means almost nothing when you actually ask what he manages. He married Vanessa 8 years ago. She's 36, works in brand strategy, which, as far as I could ever tell, means she gets paid to make other people's lies sound tasteful. They have a son, Milo, 7 years old, the only unequivocally good thing that came out of that marriage. And the only reason I let this go on as long as I did before I fought back, it started on a Thursday in October, cold enough that the last of the leaves had gone the color of rust along the fence line. I walked down to the mailbox at the end of our gravel drive, past the old red barn. Colleen had insisted on repainting every 5 years whether it needed it or not, and found an envelope from Grand Traverse County Treasury marked in red block letters, Final Noter, Delinquent Property Tax. I stood there in the wind and read it twice. $52,000 owed. 14 days before the county initiated forfeiture proceedings on the orchard. I hadn't missed a tax payment in 40 years. I balanced my own checkbook to the penny, the way you learn to when you've spent a career signing off on munitions inventories where a decimal point in the wrong place gets somebody killed. And 6 weeks earlier, sitting at my own kitchen table on a rainy Tuesday, I had wired exactly $52,000 to an account Bradley gave me because he told me the county's online payment portal was down and he'd process it through his firm's escrow service to save me the trip into town. Routing number 071000013. Reference code KESTX129. I don't forget numbers. 30 years of signing off on things that mattered taught me not to. So where had it gone? I folded the letter, put it in my coat pocket, and walked back up to the house instead of calling him right away. I wanted to hear his voice cold, unprepared, before he'd had time to build the story. I called that evening. He picked up on the 4th ring, restaurant noise behind him, silverware, laughter, a woman's voice that wasn't Vanessa's laughing a little too close to the phone. Dad, everything okay? The county sent a foreclosure notice. $52,000 past due. I sent you that money in September. A pause. Not confusion, calculation. I'd cross-examined enough witnesses in my time serving on court-martial panels to know the difference in a man's silence. That's got to be a clerical error, Dad. The county system has been a mess since they switched vendors. I paid that the same week you sent it. I've got the confirmation somewhere. The letter says 14 days. I'll drive up this weekend and we'll sort it out. Don't call the treasurer's office yourself, okay? You'll just confuse the record further, and then it'll take twice as long to fix. Let me handle it. I always handle it. He hung up before I could answer. No goodbye. Just the flat tone of a call that had ended because he'd decided it was over. I sat at the kitchen table with the fire going, the same stone fireplace Colleen and I had built with a mason from Sutton's Bay back in 1987, and I opened the leather notebook I keep in the drawer of the side table. I wrote the date, the time, his exact words. I always handle it. I flipped back through 6 months of entries and found that phrase, or one close enough to it, 4 separate times. August, September, twice in July, always attached to some discrepancy I'd raised and he'd smoothed over before I could look at it directly. 26 years commanding Marines teaches you to read a pattern before you can name it. This was a pattern. I just didn't yet know what it was building toward. Bradley and Vanessa came up that Saturday. He wore a cashmere sweater that had never seen a cherry tree in its life. She wore a wedding guest coat and the particular, practiced warmth of someone who has rehearsed a conversation in the car on the drive up. Dad, this is exactly what I told you, Bradley said, spreading papers across my kitchen table, papers full of processing codes and reference numbers that meant nothing to anyone who hadn't invented them. County system glitch. I can show you the canceled check by Monday. I let my hand tremble slightly around my coffee mug, just enough. I was worried, I said. Of course you were. Vanessa reached over and put her hand on mine. 3-carat diamond catching the kitchen light. That's completely understandable, Dad. Actually, there's something else we wanted to talk to you about. Something that's been on our minds. I said nothing. Let the silence do the work it always does. When I stopped by Wednesday to drop off Milo's drawing, she said, the stove was on, no flame, just gas pouring into the kitchen. I had to open every window. If I hadn't come by when I did. Dad, you could have. I kept my face still, kept my eyes drifting toward the cold hearth, let confusion settle into my features like a man trying to locate a memory that had slipped just out of reach. I had converted that kitchen to induction 2 years and 3 months ago, the September after Colleen passed, because I couldn't stand the smell of gas anymore. It reminded me too much of her standing at that stove making the applesauce she canned every fall. There is no gas line running into that kitchen. There hasn't been in over 2 years. I have the invoice from Pelletier & Sons Plumbing in a folder in my office, dated, itemized, signed. Vanessa had just described in vivid and convincing detail a gas leak from an appliance that did not exist. Maybe you're right, I said quietly. I've been forgetting things. Relief crossed her face fast enough that I almost missed it. If I hadn't spent 3 decades learning to watch a witness's face for the half-second before the mask resettles. They left 20 minutes later. I watched their taillights disappear down the gravel drive, then walked straight to the kitchen and stood in front of the induction cooktop. 4 ceramic burners, 1 electrical cord running to the wall. Nothing resembling a gas line anywhere in the house, not a mistake, not confusion. A story, built in advance, delivered with the practiced ease of someone who had told it before, or at least rehearsed it more than once in a mirror. I stood in my kitchen in the dark and understood, with the particular clarity that comes from a career spent listening to people lie under oath, that this was not carelessness. This was architecture. And I had just watched them lay the first brick. Sunday morning, Vanessa came alone. Bradley was upstairs. I could hear his footsteps overhead, deliberately timed. I'd learn later to let her work without an audience. I brought you something, Dad. She set an amber pill bottle on the counter beside my coffee. No pharmacy label, no physician's name, just a generic brand embossed in the plastic, and a scatter of white capsules inside. Dr. Whitfield said this would help with the memory lapses. One in the morning, one at night. Completely natural. There is no Dr. Whitfield. There was no appointment. I would have remembered driving to see a physician the way I remember every number I have ever wired, every date my wife and I ever planted a tree. That's thoughtful of you, I said, and swallowed one with my coffee while she watched, satisfied, entirely at ease. You have to understand, and I wasn't being naive. I was being exactly what 30 years in courtrooms and a career in uniform had trained me to be. Claims can be denied. Suspicion gets dismissed as an old man's paranoia. But blood does not lie. And neither does a chain of custody. Whatever was in that capsule was about to become the most honest witness in this entire case. I took 4 of them over the next 2 days, enough for a full toxicology panel, and then I stopped. That night, alone in my bathroom, I cut a small pouch from a scrap of the leather Colleen had given me for my 50th birthday, and I practiced, pill to mouth, coffee, a cough into a folded handkerchief. The capsule transferred silently into my palm. I stood in front of that mirror for the better part of an hour, watching my own reflection until the motion disappeared even to me. I want you to understand something about the man Bradley and Vanessa thought they were dealing with. They saw a widower in a barn coat who forgot where he left his reading glasses. They had no idea that for 6 years, before I ever put on a uniform full-time, I sat on courts-martial panels reviewing chain of custody evidence, or that the year before Colleen and I bought this orchard, I'd spent 11 months as an appointed advisor helping rewrite Michigan's elder financial exploitation statute. Legislation that, 22 years later, was still sitting quietly on the books, waiting for someone to actually need it. They were about to need it very badly. They just didn't know it yet. The pills, it turned out, were the least of what they were planning. By the following Thursday, I found 3 survey stakes driven into the frozen ground along the northern property line, orange tape snapping in the wind, a corporate tag stamped into the base of each one, Great Lakes Ridgeline Development, LLC, installation date, 19 days earlier, a full month before Bradley had ever mentioned a word to me about my declining health. I knelt in that frost with my bare hand on the cold metal tag and understood, all at once, that this was never about a pill bottle or a foreclosure notice. Someone had already agreed to sell land that still belonged to me to a company that had never once asked my permission, and my son's signature, or a passable forgery of it, was very likely already sitting somewhere on a contract I had never seen. I pulled that stake out of the ground, and for the first time since Colleen's funeral, I felt something other than grief settle into my chest. It felt unmistakably like the old cold clarity of a man about to build a case. That Friday afternoon I called Priscilla Vance, and I dialed a number I hadn't used in almost a decade, knowing full well I might be waking a woman who'd spent the last several years happily retired from courtroom warfare into estate law and elder protection cases exclusively, precisely because she'd grown tired of watching families do to each other exactly what I now suspected mine was doing to me. She and I had gone head-to-head twice in the 90s, once when I was still sitting on review panels, and she was cutting her teeth defending veterans against predatory guardianship claims, and once socially, over a poker table at a Marine Corps League fundraiser where she'd beaten 4 colonels and a 2-star general without blinking. I trusted her instincts the way you trust someone who has never once let you win. Warren Kessler, she said when she picked up. It's been years. What's wrong? Not a question. Priscilla never asked questions when she already knew the answer was going to be bad. I gave her the facts in the order I'd give a deposition. The wire transfer that vanished, the gas leak that couldn't have happened, the unmarked pills, the survey stakes with a development company's name on them, driven into ground I still legally owned. Silence on her end for exactly 4 seconds. Then, Warren, this is a pattern I've seen 11 times in the last 6 years, and it ends the same way every time unless the person on the receiving end fights back before the paperwork gets filed. Do you have somewhere safe to keep documentation? Somewhere they don't know about. I have a root cellar safe from before Colleen and I ever moved in. Nobody living knows the combination but me. Good. Start writing everything down, dated, time-stamped, in your own hand. not digital, nothing they can access remotely. And Warren, I need you to consider something you're not going to want to hear. If this is what it looks like, they may be planning to have you declared incompetent. It's the fastest, cleanest way to seize control of an estate without ever having to prove theft in a criminal court. If that petition gets filed before we have evidence ready, you could lose the ability to defend yourself before you ever get a hearing. I sat with that for a long moment, looking out at the orchard going gray in the last of the afternoon light. Then I suppose, I said, we'd better make sure the evidence gets there first. That was the day the operation actually began, not the poisoning, not the survey stakes, but my answer to them, because up to that point I had been a man reacting to things that were happening to him. Starting that Friday, I became something closer to what I used to be 20 years earlier, sitting behind a review panel table with a legal pad and a very long memory for detail. I called an old friend next, Ellis Rourke, 66, former Navy corpsman I'd served alongside for 4 years, now running a private forensic toxicology lab outside Grand Rapids, the kind of place that does contract work for county prosecutors when the state crime lab is backed up 8 weeks. Ellis had pulled 2 men out of a burning vehicle in Fallujah under fire from a position he had no business holding, and I had recommended him for a commendation he still kept framed in his lab office. Mostly, he always joked, to remind himself he used to be brave for reasons that mattered more than overdue invoices. Warren Kessler, he said when he answered, you're supposed to be retired and boring. I need off-the-books toxicology. No chain that leads back to my county, no record my son's firm could subpoena or bury. Blood panel and a full pill analysis. The joking stopped instantly. Who's threatening you? My daughter-in-law. Possibly my son. I don't have proof of intent yet. That's what I need from you. Tuesday morning, Ellis said. After a pause, I could feel even over the phone. Bring everything. Come the back way. No highways. Nothing that puts a plate reader anywhere near your truck. I want to be honest with you about something. Driving 4 hours each direction to a lab outside Grand Rapids in a 26-year-old F-250 with no GPS. Carrying a blood sample I'd drawn myself with supplies left over from Colleen's home hospice care is not a rational decision for a 68-year-old man to make alone in November. I knew that. I did it anyway, because the alternative was sitting in my kitchen waiting to find out exactly how far my son was willing to let this go before I had proof strong enough to stop him. Ellis called 2 days later, and his voice had none of its usual warmth left in it. Warren, I need you to sit down for this. I'm sitting. Those capsules aren't a supplement. They're quetiapine, an antipsychotic, prescribed for severe schizophrenia and bipolar mania, at nearly triple the standard therapeutic dose for a man your age and weight. In a healthy 68-year-old with no psychiatric history, sustained use at this concentration produces exactly the symptom profile someone would need to fabricate late-stage dementia: tremor, disorientation, short-term memory failure, profound lethargy. And Warren, the cardiac risk at this dosage in a man over 65 isn't theoretical. It's catastrophic. I gripped the phone and said nothing, because there was nothing yet worth saying. There's more, Ellis said. I ran your 4 samples chronologically the way you asked. The dosage isn't static, it's climbing. 15% higher in sample 2, 32% in sample 3, just under 50% by sample 4. That's not a prescription error, Warren. That's someone testing how much you can absorb before your body starts to fail publicly. That's premeditated, escalating, and it has your name written all over the delivery method. Someone close enough to hand it to you personally, twice a day, without you ever questioning it. Vanessa, handing me a pill with her hands steady and her face soft with what looked, to anyone watching, exactly like love. If I'd kept taking them, I said. How long? Ellis exhaled slowly. At that escalation curve, maybe 12 days before the cognitive damage stopped being reversible. 20, maybe 22. Before we're talking about a cardiac event a medical examiner would write off as natural causes in a man your age. They gave you a death sentence, Warren, and dressed it up as vitamins. I looked out the window of my office at the orchard. Bare now, waiting for a winter I intended very much to survive. Certify all of it, I said. Chain of custody, dated, notarized. And Ellis, thank you. I mean that. Don't thank me yet, he said. Thank me when they're both in a courtroom instead of your kitchen. I spent the next several days learning exactly how deep the debt underneath all of this actually ran. And the answer, once Priscilla's forensic accountant finished pulling threads, was deeper than I had let myself imagine, even at my most suspicious. Bradley's investment firm, it turned out, had been functionally insolvent for the better part of 3 years, a shell propped up on paper by a single failed real estate fund that had cratered during a downturn he'd bet heavily against warnings from his own analysts. The debt wasn't ordinary business debt. It was $6.4 million owed to a private Chicago lending group that did not file with any state regulator and did not, as a rule, pursue collection through the court system. 40% annualized interest, compounding monthly, the kind of arrangement men enter when every legitimate door has already closed on them. The Great Lakes Ridgeline development contract, the one whose survey stakes I'd pulled out of my own frozen ground, was for $1.8 million. 81 acres of working orchard and lakefront bluff, worth conservatively $11 million at fair market value, signed away for less than a fifth of its worth, with a 60-day clause requiring delivery of clear title, or the agreement would be voided and the debt obligation would revert in full, immediately. Bradley had 44 days left on that clock when I found the survey stakes. He needed me declared legally incompetent, needed control of my estate transferred into his name before that window closed, not out of greed alone, though I won't pretend greed wasn't sitting comfortably in the passenger seat of everything he did. He needed it because men who lend money at 40% monthly interest and refuse to file paperwork with the state do not send a polite letter when a deadline passes unmet. They send people. And somewhere in the wreckage of every rationalization I built for my son over those weeks, I kept returning to one fact that made this whole thing almost unbearable to hold. He had a wife and a 7-year-old son of his own, and whatever he told himself about what he owed me, some sick, twisted part of him had likely convinced himself he was protecting Milo by doing this to me. That didn't make it forgivable. It made it, for the first time, something I could almost understand. The particular kind of desperation that turns a man into someone his own father doesn't recognize. I sealed the real deed, the tax records, Colleen's and my original purchase agreement, and 40 years of financial documentation into the hidden compartment of my root cellar safe. A feature installed back in 1998 after a labor dispute at a defense contractor I'd once consulted for turned uglier than anyone anticipated, and one I genuinely never expected to use against my own blood. In its place, I built a set of convincing forgeries, inflated valuations, a fabricated secondary lien, bank account numbers routed to nothing, and between the pages, 3 tracking devices smaller than a grain of rice. Technology left over from a career I don't discuss at dinner parties. If Bradley photographed those documents to send to his lenders or his developer, I would know the moment, the location, and the device he used to do it. Sunday, before dawn, while Bradley and Vanessa were 4 hours south with her family, I knelt in the dark of that root cellar and finished the trap. And when I closed that safe and spun the dial, I understood something Priscilla had tried gently to warn me about on the phone days earlier, that once this began, there would be no clean way to end it that didn't cost me something. I just didn't yet know it would nearly cost me my own freedom first. The following Tuesday night, the surveillance team arrived. Priscilla had connected me with a retired Army Sergeant Major named Otis Reyes, a man who ran a small, quiet security consulting outfit out of Traverse City, and who, it turned out, had been the non-commissioned officer standing beside Ellis Rourke on the day Ellis pulled those 2 men from that burning vehicle. Reyes didn't ask why I needed hidden cameras in my own house. He asked where I wanted them and how fast I needed the installation finished. 23 minutes. Cameras behind the fireplace mantle Colleen and I had built with our own hands, wired directly into the house current so battery changes would never give them away. Thermal sensors disguised as weather monitors zip-tied into the branches along the property's tree line, giving Reyes's team a clean 2-mile perimeter view of anything approaching the house after dark. He shook my hand before he left, the way men who've served together shake hands. No words needed, No explanation owed. 2 nights later, a little before midnight, the tablet Reyes had given me buzzed with an alert. Headlights, 2 miles out, coming up the county road in heavy snow. I had less than 3 minutes. I stripped down to thin cotton pajamas, no coat, no shoes, and walked out my own back door into 8-degree wind, barefoot on frozen gravel that felt, within seconds, like walking across broken glass. I stood in the middle of the yard, raised my arms toward the tree line, and began calling my dead wife's name into the storm, the way grief actually sounds when it's real, because some part of what I was about to perform had never needed rehearsing at all. Colleen. Colleen, where did you go? Please. I can't find the house from here. Bradley's sedan slid into the driveway 90 seconds later. I heard the door open, heard him say, low and satisfied, to whoever was in the passenger seat, "Get this on camera. This is exactly what we needed." Vanessa's voice, sharper, dragging me by the arm back toward the house, my bare feet leaving faint red marks in the snow that would look, on video, exactly like the collapse of a dying man's mind. What Bradley didn't know, standing there filming his own father wandering in a blizzard with his phone held steady, and his face lit with something that looked disturbingly close to relief, was that Sergeant Major Reyes's thermal cameras had already captured me, stepping outside a full 90 seconds before his headlights ever crested the hill. His footage would show a man in the grip of dementia. Mine would show a man checking his watch on the porch, timing his performance to the second his son's car was due to arrive. They left 20 minutes later, Bradley still reviewing his video in the driveway, already, I imagine. Drafting the affidavit in his head, I sat by the fire afterward, my feet finally thawing, and looked at the photograph of Colleen on the mantel, the one from our 30th anniversary, her laughing at something just out of frame, the cancer already inside her, though neither of us knew it yet. "I know how this looks," I said to the empty room. "I promise you I know exactly what I'm doing." She didn't answer. She never did anymore. But for the first time in 2 years, I felt something other than grief when I looked at her picture, and I think, of all the things I lost that November, that might have been the one that surprised me most. 3 days later, Priscilla called with news that arrived faster and harder than either of us had prepared for. They filed, Warren, yesterday afternoon. Emergency ex parte conservatorship petition, Grand Traverse County. Hearing set for Friday, 2 o'clock. Judge Simon Ashworth presiding. "That's not the 2-week runway you told me to expect." They accelerated, she said, and I could hear the tension threading through her usual calm. "Which tells me your fake documents worked faster than we planned for. The tracking devices show Bradley's firm accessed and transmitted them twice this week. Once to the lending group's counsel, once to Great Lakes Ridgeline directly. They think they're closing the deal. That's very likely what's forcing this timeline, Warren. There's something else." 2 psychiatrists filed sworn affidavits attached to the petition, a Dr. Aldous Fenwick and a Dr. Renata Cho, neither local, both claiming they evaluated you personally within the last 3 weeks. I've never heard either name in my life. I know. My forensic team is already pulling the financial trail. But Warren, listen to me carefully, because this part matters more than anything else I'm about to say. If the judge asks you basic competency questions Friday and the quiapine were still active in your system, you would very likely fail those questions, whether you meant to or not. They built this timeline assuming that drug would still be working. It isn't, because you stopped taking it 3 weeks ago, and Ellis has the blood work proving exactly when. That gap between what they expect to see Friday and what's actually standing in that courtroom might be the only advantage we have left. I looked out at the orchard, gray under an early snow, the row where Colleen was buried barely visible through the falling flakes. "Then Friday," I said, "we'll let them find out exactly how wrong they were." Friday morning, 2 sheriff's deputies and a county social worker arrived at 7:40, exactly the way emergency orders are always served, early, official, no room negotiated for dignity. I let them in. I'd already packed a bag the night before, my oldest barn coat folded on top, because I understood better than they did exactly what role I was about to play for the next 72 hours. Dr. Helena Marsh conducted the psychiatric evaluation that weekend at Cedar Ridge Behavioral Health outside Traverse City. A real doctor, this one, unlike the two ghost affidavits attached to Bradley's petition, but working entirely from a case file built on those forged evaluations and Bradley's video of me screaming for Colleen in a snowstorm. I performed exactly what the file expected of me. I forgot what year it was. I forgot my grandson's name and then remembered it 30 seconds later with visible staged distress. I let my hands shake through every cognitive test she administered. What Dr. Marsh had no way of knowing was that I'd spent 11 months in my 40s helping draft the very statute her hospital's intake protocols were built around, and I knew precisely which symptoms belonged in a convincing performance and which ones would raise a real clinician's suspicion. Vanessa visited Sunday afternoon, wilted grocery store carnations in hand, and leaned close in the visiting room under the camera mounted in the corner. "Don't fight it tomorrow, Dad," she whispered. "It goes easier for everyone if you just cooperate." I let my eyes go watery and touched the flowers with a trembling hand and said nothing that would tell her. I already knew exactly what tomorrow was going to cost her. Monday morning, they dressed me in Vanessa's chosen wardrobe, a fraying flannel shirt, jeans with a permanent grass stain at the knee, boots scuffed until they looked 20 years older than they were. The message was plain enough. Present the judge with a broken old farmer who couldn't be trusted with a checkbook, let alone 81 acres of lakefront orchard. I wore every piece of it into room 4C without complaint, because Priscilla had taught me, over 3 decades of watching each other work, that the most dangerous man in any courtroom is always the one everyone else has already decided to underestimate. Which brings us back to where I started this story. The bailiff called the case. Bradley sat at the petitioner's table beside Palmer Voss, his attorney, and Vanessa beside him in a coat that cost more than most of my neighbor's monthly mortgage payments. I shuffled to the respondent's table, lowered myself into the chair with exaggerated difficulty, and folded my hands over my old cloth hat. Voss opened smoothly, laying out the psychiatric affidavits, the video from that snowbound night. Bank statements, he claimed, showed a pattern of confused, erratic transfers. Judge Ashworth listened with the careful, patient attention of a man who took these petitions seriously and had clearly seen too many families torn apart over exactly this kind of dispute to rush toward a decision. "Mr. Kessler," Ashworth said finally, turning to me, his voice gentle in the particular way judges use with people they've already been told to consider fragile. "Do you understand why you're here today?" I lifted my head slowly, let my eyes stay unfocused a beat too long. "The taxes?" I murmured. "Is this about the taxes?" Voss started to speak. Ashworth held up a hand, and something in his expression had already begun to shift, not toward sympathy exactly, but toward the sharper attention of a man who'd noticed a detail nobody else in the room had caught yet. He was looking at the exhibit binder open in front of him, at a photocopy of the property deed Bradley's petition had entered into evidence weeks earlier, quietly, almost as an afterthought, alongside the competency filing, proof, they intended, that transferring the property into Bradley's name had already been fully authorized and completed. A fait accompli the judge need only formalize by declaring me unfit to contest it. That was when Judge Ashworth set down his own pen, looked directly at me, and asked the question that would end my son's case before Palmer Voss ever got to make his closing argument. "Mr. Kessler, before we proceed any further, I need you to explain something to me personally. Why does your son's name appear as sole owner on the deed to the house you've lived in for 40 years? I straightened my spine, slowly, vertebra by vertebra, and let the performance I'd been carrying for 3 days fall away like a coat I no longer needed. I raised my right forearm into the light, sleeve pushed back, and showed the courtroom the pale, lightning-shaped scar that ran from my wrist to toward my elbow. The scar I'd carried for 20 years, since a burning Humvee outside Fallujah, and a young corporal I'd pulled clear of it with seconds to spare before the fuel line went. Judge Ashworth's face went white. His hand, halfway to his gavel, stopped in midair and began very slightly to shake. "That scar," he said, voice dropping to something barely audible. "Colonel Kessler, it's you. Behind me, I heard Bradley's chair creak as he sat forward. I heard Vanessa's sharp intake of breath. "It's been 20 years, Simon," I said, and I let my voice come out exactly the way it needed to. Clear, level, entirely without tremor. "Do you still remember the vehicle?" Nobody in that courtroom, including my own son, had ever known that the young man I'd pulled out of a burning Humvee 2 decades earlier had gone on to law school on the GI Bill and then onto the bench of Grand Traverse County. I hadn't known it myself until Priscilla's paralegal, running a routine background check on the judge assigned to our hearing, had found a decorated Marine Corps veteran's name buried in his official biography and put 2 facts together that neither of us had dared hope would connect. "Your Honor," I said, and I answered his question at last. The one that had made his own attorney's associate finally set down his pen. "My son's name is on that deed because 6 weeks ago I let him convince me to sign it over for what he called estate tax planning. I signed it because I loved him and I wanted to believe him. And then I spent the next month watching him and his wife build a case to have me declared unfit to ever contest that signature. Because they needed this house and this land. Gone from my name before a debt neither of them ever told me about came due to people who do not send lawyers when their money is late. I set a leather notebook on the table in front of me, 4 months of dated entries, in my own hand, exactly as Priscilla had told me to keep them. I have a full toxicology report showing systematic, escalating poisoning with an antipsychotic medication I was never prescribed. I have forensic accounting showing 2 psychiatric affidavits paid for from an offshore account in my daughter-in-law's name. I have thermal surveillance proving the video entered into evidence. Tonight was staged to the second. And I have documentation showing my son forged my signature on a development contract for land he did not yet legally own, sold at 1/5 of its value to satisfy a $6.4 million debt to an unlicensed lending group that does not, as a rule, collect through the courts. Palmer Voss had not written a single word since I raised my arm. He simply sat there, pen resting on his legal pad, watching his entire case dissolve in real time. "Your Honor," I finished. "My son's name is on that deed because I let him put it there. My answer, if you want the whole truth of it, is that I let him think he'd won, so that I could show this court exactly what winning was going to cost him." Judge Ashworth called a 15-minute recess. When he returned to the bench, his voice carried none of its earlier gentleness. "This court finds clear and convincing evidence of fraud, forgery, and elder financial exploitation," he said. "The emergency conservatorship petition is denied and vacated in full. Mr. Kessler's competency is affirmed without qualification. I am referring this matter immediately to the county prosecutor's office, and I am issuing a warrant for the arrest of Bradley Kessler and Vanessa Kessler on charges including elder abuse, conspiracy, and administering a controlled substance with intent to harm." Bradley tried to bolt for the side exit before the deputies reached him. He made it 3 steps. Vanessa didn't run. She dropped to her knees as the deputy cuffed her wrists, twisting to look back at me, tears already streaming. The same performance she'd given me at my own kitchen table months earlier. "Dad, please. I'm family." I looked down at her, and for the first time since October, I let myself say exactly what I meant. "You chose this," I said. "The morning you put that bottle on my counter, you chose everything that comes after it." 3 weeks later, Bradley pleaded guilty to wire fraud, conspiracy, and elder financial exploitation. 11 years federal, restitution of $2. $1 million to Great Lakes Ridgeline for the voided contract, permanent disbarment from any future licensed financial work. Vanessa pleaded to administering a controlled substance with intent to cause bodily harm, with a sentencing enhancement, once Ellis Rourke's dosage escalation charts were entered into evidence. 7 years, all personal assets forfeited to a restitution fund. I sat in that second courtroom and felt none of the satisfaction I'd expected to feel. Only the particular hollow ache of a man who had won a war against his own blood and lost the only son he had in the process. Milo comes to stay with me every other weekend now, by court order, and by his mother's family's grudging cooperation, and by something gentler than either of those. My own daughter-in-law's sister, watching a 7-year-old boy lose both his parents to prison in the same month, decided a grandfather's orchard was a better place for him than anywhere else available. Last month, he found the old canvas duffel bag in my closet, the one with my unit insignia still stitched to the strap, and asked me what the scar on my arm was from. I told him the true version, the fire, the corporal, the 20 years between that night and this one. He was quiet for a long moment, turning the bag over in his small hands. "So you saved somebody a long time ago," he said finally, "and then he saved you back without even knowing it was you." I didn't have an answer sharp enough for that. I don't think I've ever had one. I signed the orchard the following spring into a permanent land trust in Colleen's name, protected forever from ever being sold, mortgaged, or transferred out of agricultural use, administered by a board that includes Priscilla Vance, Sergeant Major Reyes, and, when he's old enough to understand what it means, Milo himself. 81 acres that no lending group, no development company, and no desperate signature will ever be able to touch again. Most mornings I still walk the northern row before the sun clears the bluff. Some mornings Milo walks it with me now, small and quiet beside me in the frost. And I find myself telling Colleen things I never thought I'd get to say out loud again. That the trees are safe, that her grandson knows her name, that the man who tried to take all of it from us answered for what he did in a courtroom with a real judge and a real gavel and a scar neither one of us ever expected to matter again. If this story found you today, I'd ask you to sit with one question before you go. What would you have done sitting at that kitchen table the first time someone you loved handed you a story that didn't quite add up? Leave your answer below. I read everyone. And if someone in your life needs to hear that it's not too late to fight back, send this to them today. Thank you for staying with me until the very end.